Morning, everybody. Everybody's starting to trickle in a little bit. We have 10 participants so far. My name is Anthony Amaral. I am the chair for the Kent Washington Association of Realtors Education Board. Today, we have Michael Crone, Senior Vice President of Equity National Title, presenting to us on our Lunch and Learn for this month. He will present on title training for the realtor basis. Michael, go ahead. You're all set.
Thank you. And good morning, everyone. Just a little bit about myself. I'm a practicing attorney for over 30 years. I say over 30 years because it's a lot of years, over 30 years, but I don't admit that. I am a member of the Massachusetts Bar and the Rhode Island Bar. I've primarily practiced real estate law in my career. Some of you may have been on one of my classes. I've done a lot of realtor education classes in Rhode Island and in Massachusetts. I've probably handled personally over 15,000 real estate transactions, and I've been involved in organizations that probably total over 100,000 real estate transactions. So it's something I know a bit about, but as I've always learned, there's something new to learn all the time. So some of you may be new to the business, some of you may be involved in the business for quite some time. There's always something to get out of every presentation, and I hope that's what I'm able to impart to you today. I work for Equity National Title. Equity is a national provider of real estate closing services. We're headquartered in Rhode Island. Our main focus is in Rhode Island and New England states. We're here to help residential real estate transactions with buyers, sellers, represent lenders in these transactions. We're always available to assist you. And that includes if you have a buyer that wants a review of the purchase and sale. We get this all the time. They sign the purchase and sale agreement, they want to review it. Happy to do that. Or if they want us to work with them, a seller wants us to draft it for them. We have attorneys on staff to do all of these things. So happy to assist you. And if you've got any snowbirds that are going down to Florida or the Carolinas, as I said, we transact in all 50 states. So happy to help you with your clients if they're doing that as well. I've got my slides up on the screen here. So title training. What are we going to do today? What are we going to talk about today? Well, let's move to the next slide. We're going to do a little bit about basic real property concepts. What does that mean? How do we hold title? What is a warranty deed? How does it differ from a quitclaim deed? Things of that nature. We're going to talk a little bit about title insurance. What is title insurance? What does it mean? We're going to talk about some common title issues, exceptions. Talk a little bit about title search. If you'd like to ask a question, feel free at any time. You can either chat and put the question in there, or if you'd like to unmute, and I would ask you that you mute your microphones, but if you'd like to unmute and ask a question at any time, please do so. You're not interrupting me. I'm happy to answer questions. I can't be interrupted. I'm that type of speaker. Don't worry about it. You can't throw me off. I've done it too many times. So please feel free to ask anytime. All right. Okay, so let's talk about what is real property as compared to personal property. When you buy the house, what are you really buying? People always ask this question while buying the house. What you're buying is the land. The house comes with it. And a lot of people don't understand that. When we draft the purchase and sale agreement, what we're really drafting is for the purchase of the real estate. So purchasing the real estate is real property. The things that come with real property are personal property. Now, what would you call the actual house itself, the building itself? Well, it's not real property. That is personal property to a certain degree, because the real property is the land that we purchase. And I always get a kick out of people, they'll say, well, it's a vacant parcel and they're going to build a house on it. So we don't need title insurance. Why? Well, because there's never been a house on it. Unless God just made that parcel, there's issues that could be related to the real estate. So understanding the difference between real property and personal property is essential because we got to know what we're actually talking about. Personal property is everything other than the real estate. So when we say real estate and real estate transaction, we're talking primarily about the land with the house on it, the things inside the house, anything that's included outside of the house in the transaction would be personal property. So if they're including the TVs, the lawnmower, things of that nature, that's personal property. Ownership, all property includes the rights of ownership, the right to possess, to use, to encumber, and to transfer the property. These are the rights of ownership. Now, these compare to the rights of getting a leasehold, leasing a property. They're different. And we'll talk about that in a few minutes. An owner of real property obtains a bundle of rights. So what are those rights? When you're owning real property, what are the rights that you're actually given? You're given possession of the property, sole possession of the property. You're getting control of the property. You get to exclude people from the property and things from the property. You get full enjoyment of the property. And you get the right of disposition, the right to sell the property, or the right to lease the property, or the right to give interest in the property. An owner may transfer some or all of these rights. For instance, what is an easement? An easement is transfer of certain aspects of your ownership right. An easement is allowing someone to use part of your property to do something. For instance, a driveway easement allows someone the right to use your property for their driveway. That is giving them a right to your property that you already had. So we can give up some of our rights to the property without giving up all of our rights to the property. So easements are a big one of those, rights of ways. We can give people rights of ways to our property. And of course, we can give all of the property to someone, and that would be transferring title of the property. What is the interest that an owner gets really in this part of the country, especially, but primarily throughout the United States? It's an ownership called fee simple. It's an old British legal term. And remember that all of our laws came from the laws of England, except for Louisiana. Where did those laws come from? France. Because France owned Louisiana when we purchased it. But all the rest of the states come with laws that were ingrained in England. And so we have these old English terms like fee simple. You ask an attorney what a fee simple term means, and most of them won't have any idea. It's an ephemeral concept. I can't. Sometimes people ask me what's the difference between fee simple and something else. Fee simple is basically the greatest estate one can have in real estate. It includes all the rights that go with real property, as compared to, say, a life estate or a lease estate. So when we take property in fee, if you ever hear that term, he holds the property in fee, it means in fee simple. They own all the property. Old terms, but nonetheless terms that we still use. And sometimes we put them in a deed. For instance, if we're giving up, someone has a life estate in a property and we're deeding that life estate out, we say that they deed their fee in life or their life estate fee, meaning that is the fee that they're giving, as opposed to fee simple, which is the actual ownership of the property. We do have limitations on real estate. Those limitations are established by the government and the process that we have. So for instance, local ordinances can limit what you can do to real estate. Houston was the last major city in the United States that didn't have zoning laws. And that was up until the early 80s, I believe, or maybe 70s. And basically a power plant could be put right next to a mansion. There was no zoning. And most of our cities, most of our towns didn't have zoning really until the 1800s. And they established these local ordinances and zoning laws that would restrict the types of buildings that could be within a certain area. So for instance, if you have 1 acre zoning in a particular town or city, nothing below the 1 acre can be used as a buildable lot unless you get a variance from the town. So we have local ordinances that govern what can be used in the town, what can be done with the town, with the property. We also have eminent domain. If a town has a public need for that particular piece of property, they can take the property by what's called eminent domain, and they'll pay you the fair market value for that property. Now, can the government take your property anytime they want? No, they have to have a true public need for that property. Now, generally speaking, they're not going to take someone's home unless it absolutely is essential. But you may own a vacant parcel of land somewhere, and the town thinks they need it for a park or a school, and they'll take it by eminent domain if you don't want to sell it to them. And that does happen. And of course, we have taxation. In this part of the country, we tax real estate. Perhaps the most regressive tax of any tax in the United States is a real estate tax. It has absolutely nothing to do with the taxpayer's ability to pay it or the taxpayer's income. It has solely to do with the value of the land. And as realtors, this is one area that I always profess you need to really start paying attention to. And that's because taxation is what's going to make certain communities impossible to live in. When your real estate taxes become higher than your mortgage, and I see this in many instances today, when your real estate tax, monthly tax escrow is higher than your principal and interest payment, you know there's a serious problem. In the realtor community, we've always professed that education is the biggest thing, our schools and so forth, and we've done a great job of that. I'm a realtor as well. I don't really practice it, but I've held my license for 40 years. But we've got to be very careful with things like taxation, because that is going to affect our real estate and our ownership rights of the real estate. Because at some point, if a community is, the high taxes are so high, people just won't be able to live there. We also have private things that can be established to restrict property. Deed restriction. We can sell a property and put a restriction in there that nothing more than, or nothing less than a 2,700 square foot house can be built, or that only a colonial house, or that the house plan has to be approved by a design review board. These are very common restrictions that are put into deeds and subdivisions of new housing lots, so that there's a consistency of the type of housing that's going to be placed on those lots. If a developer goes in, has a 20-acre lot, a 20-acre subdivision, puts in 15 lots, wants to keep those lots at a certain price level, wants to make that development of a certain quality, they're going to put minimum requirements, 2-car garage, 2,700 square foot houses, things of that nature. Covenants, conditions, and restrictions are kind of the same thing. We put these generally on subdivisions as opposed to individual house lots, and they're very common. There used to be covenants and restrictions that dealt with race, and they were throughout New England. Most every state had deed restrictions going back to the 1800s that restricted on the basis of race. Those were outlawed in every state in New England. And if you go back in old deeds, you'll see some of those, but obviously they cannot be enforced. But most of the common conditions really relate to use of the property, maintaining some consistency in a neighborhood. Declaration of a condominium. A condominium basically establishes the property as being owned by a group of people, with each owner having their own individual unit. So in a condominium, you own the unit that you have just within the 4 walls. Everything outside of the 4 walls of that unit is owned by the condominium association. It maintains the outside of the unit and all of the common areas. You own and maintain the inside of your condominium unit. So declarations of condominiums establish more restrictions, private restrictions on the use of property. Who owns what? Who controls what? Who can operate in a way or a certain way? What can you do with your property? They have bylaws as to how long you can play music, how late you can play music, things of that nature. And as we said, easements. These are private restrictions that can be put on property that will allow somebody to do certain things. One of the biggest ones we see are driveway easements. And driveway easements in New England are oftentimes not recorded. They were given by someone to use a driveway over someone else's property years before. Now, how does this happen? Generally speaking, it's done because many of the properties that we had were farms or large estates. And over the years, the owner would separate a parcel out for their daughter and separate another parcel out for their son or for a niece or nephew. And there wasn't a driveway that was necessarily used for each of these. They used a common driveway because the common driveway just made sense. They were all family members. So there was no need for each of these parcels to have their own driveway out to the street. And in fact, many of them couldn't, because there wasn't enough frontage in the street to support all of this. And so they had these common driveways. That's basically where they come from. And they weren't recorded. This creates a bit of a problem when you try to get a mortgage on a property that has a common driveway with no recordation of that easement. A lot of lenders, a lot of investors don't want to see that. They want some kind of agreement to know that if there's a problem with the driveway, all of the parties that have the right to it have committed to repairing it, maintaining it, things of that nature. This is when we sometimes run into a problem if we have a shared easement or right of way. What are the basic property concepts? Well, the deed that you see most often in Rhode Island is a warranty deed. Now, what does a warranty deed say? All of these things. The grantor assures to the buyer that the grantor, and the grantor is the party selling the property, has good title. There are no defects in the title. There are no outstanding interests of other third parties, meaning they don't have anything that's not recorded, other like an easement and things like that that's not recorded. There are no mortgages other than the ones that are going to be paid off at closing. There are no unpaid taxes other than those that are going to be paid off at closing. No open liens or encumbrances other than those that are going to be paid off at closing. The grantor has lawful authority to sign and deliver the deed, meaning that person actually owns the property. And the grantor, the seller, will defend these statements and those of past owners. So think about this. Have we ever heard of anybody suing a seller on the basis of their warranty granted in the deed? Honestly, I've seen one lawsuit based on this in my entire career. Yet we still offer these warranties all the time, but no one ever sues anybody if they turn out to be not correct. Nonetheless, that's what the warranty deed says. So it's basically granting everybody, that anyone who has owned the property, for yourself and for your past owners, that there are none of these items that are on the property or affecting the property. That's the highest deed that you can get in Rhode Island. That's the most secure deed that you can get in Rhode Island. Now, you find out that there was an unpaid tax, that there was a lien that was on the property, but it wasn't recorded. You go after the seller. What's your likelihood of success? Slim to none. Meaning that you're going to spend a lot of money trying to sue the seller. And in the end, the question is, who knows? I have a question here from Lorraine. How do you remedy driveway easement if it has not been recorded? Try to get the other owners that are affected by the easement to come up with an agreement. And there's simple agreements we can draft. They basically say we all agree to maintain it, we all agree to use it, we all agree not to restrict the other's use by placing trash barrels or cars in the driveway or things of that nature. It can be 3 paragraphs long. It's pretty simple to do. But yeah, you would check with an attorney to do it. Okay, so what's the next type of deed? Quitclaim deeds. Special warranty deeds. A special warranty deed says the grantor has good title, there's no defects, no outstanding interests of third parties, all the same things, except the grantor will defend these statements for themselves, but not for past owners. So special warranty deeds, we don't see too many of these. We generally see warranty deeds and quitclaim deeds. In Massachusetts, the quitclaim deed is basically the warranty deed. They do have a warranty deed. No one ever uses it. It's not really used by anybody. But the quitclaim deed is the most prevalent deed in Massachusetts, warranty deeds in Rhode Island. And then we have the quitclaim deed. And the quitclaim deed in Rhode Island basically says it's yours. I make no warranties. There are no representations of ownership. I'm just giving you the property. And we do see quitclaim deeds. Now, generally speaking, we'll have quitclaim deeds between family members, things of that nature. Then no particular need to do warranty deeds. But then again, nobody really cares. The warranty deed or quitclaim deed between parties. We do a lot of deeds for individuals who are getting mortgages, and the husband was on the deed and they're married, and the husband and wife now want to be put on the deed. So we'll draft a new deed from the husband to the husband and wife. And we'll talk about tenancies in a minute. So this quitclaim deed doesn't offer much. And the interesting thing about quitclaim deed is I've separated the term quit and claim here. I don't know what it is. Some places use quitclaim as one word. Some people use quitclaim as two words. I don't really know what the answer to that is. I don't think there is an answer. Tenancies, ways to hold title. How can we hold title when we own real estate? And this is extremely important. If you make a mistake as to how the parties hold title, this can truly affect the parties if something happens to one of the owners. So we have a few types. First of all, we have tenants in common. And we say there's no right of survival in tenants in common. And what that means is, so we have A, B, and C here owning the property, tenants in common, 1/3 each. When A dies, where does her interest go? When she dies, her interest goes to her heirs, not to the other two owners. There is no right of survivorship, meaning that the surviving owners don't take her interest. It goes to her heirs, whoever they are. So we've got to be very careful here. If we've got a parent and two children owning real estate, and it's their intention that when one dies, the other person or the other two should get that person's share, it should not be tenants in common. Now, if no tenancy is placed on the deed, it automatically defaults to tenants in common. So if we don't place it, and people make mistakes and they forget to put the tenancy in the deed, it's tenants in common. So if that wasn't the intention of the party and A dies, A's share now goes to the others, whoever his heir or her heirs are. That may not have been the intention of the parties, and someone's going to get sued. And they could lose control of the property at some point because now they have a third party in there or third parties in there that they don't want to hold property with. So tenants in common, the most basic element, it's the default. Most parties, if they're holding the property together, will hold it as joint tenants. Joint tenancy has a right of survivorship. So when A dies, her interest automatically passes and divided among B and C. So the decedent's share goes to the other two survivors, the right of survivorship. It's not that every time three people or two people own property, they want it as joint tenancy. They may not. For instance, you have a young couple and they're not engaged, they're not married, and one of the parents is helping out the two in getting the property to buy it. They've given them a big piece of the deposit. In that instance, those two people will oftentimes hold it as tenants in common. Why? Because the parent of the parent that gave the money doesn't want all of that to go to the survivor of the two of them, especially if they're not married and they don't know what their longevity of the relationship will be. And so in that instance, we oftentimes recommend holding as tenants in common so that if, God forbid, his daughter dies that he gave the money to, the father is made whole with the deposit and what the father put into the property. So joint tenancy, when parties want survivorship to occur, when they want the property to go to the other parties, that's what we utilize. And then we have tenancy by the entirety. So in Rhode Island, you have the right to a tenancy by the entirety. Now, it's like a joint tenancy. If one of the spouses dies, the share goes to the other spouse. One of the other things that's unique to tenancy by the entirety, and it can only apply to married people, including same-sex marriages. It can only apply to married people, and most states have tenancy by the entirety. New Hampshire doesn't. A few others don't. Neither in Rhode Island, neither one can sell without the other's consent. So this is a protection, for instance, to a spouse whose other spouse may be a degenerate gambler or someone who can't be trusted, and they want to protect their interest in the property. That doesn't mean necessarily that a lien can't apply to the other spouse's share of the property. It can. But that person can't sell their interest in the property to someone else so long as they're married and hold as tenants by the entirety. This is how we always hold title to real estate when the couple is married. Only if an estate planning attorney feels there should be another way to hold it do we ever change that. Other types of estates. We have life estates. What's a life estate? A life estate is when someone sells the property to someone else, basically usually gives it to their kids, and retains for themselves an estate to use and control the property for their life. Now, this is a way for, it was primarily a way for people in the 80s and 90s and early 2000s to take the property out of their name so that in 4 or 5 or 7 years, whatever that holding period was, they could qualify for Medicaid if they had significant medical expenses, like going into a nursing home as time went on. If they didn't, the house was could be attached by Medicaid groups, the state, and any federal Medicaid organizations, and pay for the home, the health care services that they receive. But if they deeded it and retained only the life estate in themselves, then they could use the property. They could do what they wanted to with the property. The other people who they sold the property to, generally, again, they didn't sell it, they gave it to their kids, couldn't kick them out of the property. They had the right to use it, no matter what was done. So life estates still exist. I don't know how much they're used for estate planning anymore. I don't get involved in estate planning, but we do see them. The problem with life estates is this. We have Auntie Joan, and Auntie Joan gives a life estate to herself and gives the rest of it to her niece and her nephew. And then Auntie Joan becomes infirm, mentally infirm. Now what happens? Auntie Joan can't sign a deed giving away her life estate. 2 kids have the property and they need to refinance the mortgage, or they need to do something with the property, or they need to sell the property. They can't, because they would need a deed from Auntie Joan to do that. So we're very careful with life estates with elderly people, because if they become mentally infirm, they can't sign the deed and they can't do anything with the property. We have to get a guardian appointed to execute that deed. So life estates aren't necessarily the greatest estate planning tool. Trusts are generally done more with that. We can talk about that another day. Dower and courtesy and leasehold estates. Okay. So we had the fee simple, which was perpetual. We have the life estate, which we just talked about, and it's based on the person's life. So for their life, for the duration of their life, they have the property. They have the right to use it. They're actually called a life tenant. Dower and courtesy. So dower and courtesy has been abolished. This was an old term that said that, basically what it was that women were considered chattel of men, and that a woman's right didn't really exist in ownership, and anything that the woman had automatically was owned by the husband too, even if the husband wasn't on the deed. There was some corollary to that, the dower and the courtesy. One was for the male, one was for the female. We abolished a lot of that. However, Rhode Island keeps what's called a life estate for the spouse. Whenever any person dies, leaving a husband or wife surviving, and that's if they owned it in their own name, not as joint tenants or tenants by the entirety with the other spouse. The real estate owned by the decedent at his or her death shall descend and pass to the husband or wife for whose natural life is subject. So meaning that if you own the property in your name and you died and your wife was living with you in the property, the wife has the right to stay there for the remainder of her life. This is unique in Rhode Island. We don't see this in other parts of the country. We certainly don't see it in other New England states, certainly not in Massachusetts either. And then we have leasehold estates. Leaseholds are the temporary right for possession without conveying title. All you're doing when you give someone a lease is you're giving them the right to use the property, but to use it exclusively. So we also have things called licenses. You ever try to go to a football game? You ever look at getting season tickets, let's say, of the Patriots, right? Or the Red Sox up in the club. What you're getting if you want to buy a club seat is you're getting a seat license, the right to use that seat, but not exclusively. A leasehold is different. When you give someone a lease, a tenancy to occupy the property, you're giving them the absolute right to use that property on their own without interference from anyone else. The reversionary, meaning once the lease has expired, the possession goes back to the landlord, is the term that we use when we talk about what happens at the end of the lease. And each lease has a term. It might be that there's a written lease and the term is spelled out in the lease. It could be a tenancy, a tenancy at will, in which it's determined by a notice to quit within 30 days. So it can be terminated any time with 30 days notice. We see sometimes land that is in a 99-year lease. It's not unusual to see this. We're going to see it in our oldest communities, usually seaside communities, where groups held the property and kept it in a leasehold so they can control it. We see this in Martha's Vineyard and in Nantucket in Massachusetts, where religious communities held the property under a 99-year lease because they wanted to control who would live there, and they wanted to control the sanctity of their neighborhood. We don't see much of it, but when we do see it, it's not problematic necessarily, but we want to make sure that the lease term is as long as the mortgage term if they're going to get a mortgage. No lender is going to loan on it if it's a 99-year lease and there's only 12 years left on the lease and they want a 30-year mortgage. A question came in from Nancy. Can one party sell without the other in a joint tenancy situation? Yes, they can. They can sell their share, and so can those in tenancy common. Yes. So leasehold estates, I mean, we could have 5 sessions on leasehold estates and landlord-tenant law and all of those things. We won't get into that today. But leasehold is a way of having possession of the property without ownership. What about liens? Liens affect all of our properties from time to time. A mortgage is a lien, a tax lien. We could have a local tax lien, a property tax lien. We could have a state tax lien for income taxes. We could have a federal tax lien. We can have liens by people that have sued us for something that we owe them. And the one thing to remember about liens is the priority of the lien matters. The first to record is the first to be presumed to have priority amongst all of the others. So when we go to record with a document or a lien or a deed in Rhode Island, as in Massachusetts and some other states, we have what's called a race to record situation. The first to record is is presumed to have the best title or the best lien, the first in line to be paid. It's presumed. Doesn't necessarily mean that it is, but especially with liens, that presumption is very strong. With deeds, if someone proves that there was a fraudulent deed put in front of them, then that presumption can be rebutted with evidence of that fraud. But with a lien, really, the first to record is indeed heavily presumed to be the first to be paid in the line of presumptions. An unrecorded lien, they come after all the recorded liens. So for instance, if we do a transaction for a lender and it's a mortgage transaction and we forget to record the mortgage, and then another mortgage is put on, say an equity line, and a lien is put on by some kind of a creditor, and the person goes into bankruptcy, the mortgage, which funded the purchase of the property, will stand third behind the other two because they're recorded liens. And the lender would be paid last. However, in most situations, obviously, if we record the mortgage, the lender is going to be in first position. And that's one of the reasons we check the title to the property. We're trying to determine, does anyone have a lien on this property that isn't being paid off at closing? If they do, then we really can't get a first mortgage. If the mortgage is going to be second behind someone else, it's not a first mortgage. Equity lines are second mortgages. Why? Because there's a first mortgage, and then the equity line stands behind the first mortgage in recording. And equity lines also have language in them saying that they stand behind the first mortgage. So even if we recorded them out of order, they still subordinate. We'll talk about subordination. What types of liens do we have? We have involuntary liens, court judgments, and prejudgment liens. So if you file suit against somebody and you feel that that person is going to do something to try to eliminate your ability to collect your judgment someday, you can put a lien on their property, a prejudgment lien. You can ask the court, please put an attachment on this property until we resolve this litigation. So I'm sure that if I win, I will collect my money. We have federal tax liens. We have state tax warrants. We have mechanics and construction liens. And a mechanic lien, what is that? We hear about it all the time. Is it really a lien? It is to a certain degree. And a mechanic's lien is imposed when a contractor or somebody that provided services to a homeowner isn't paid. And they will present their contract. They will record a document indicating that they had a contract, that they didn't get paid, and what they're owed. That, in essence, is looked at as a lien by everyone looking at title, and it would have to be resolved before anyone would sell or mortgage that property. So they do exist. And we have to be careful of them because they can pop up after the sale. So especially in new construction. We have new construction and the general contractor didn't pay the electrician. Can the electrician put a mechanic's lien on the property? Yes, they can. They can. And so this is something that we want to make sure we look into. We don't necessarily ask for all of the bills to be paid when we're doing this and representing a lender, but nonetheless, it's something that we're always careful of. And we actually have what's called a mechanic's lien affidavit, which the seller will sign at closing, saying that they don't owe any work for it done in the last 120 days in Rhode Island, and that if they do, that they agree to cooperate with the title insurance company to pay that lien. Voluntary liens are things like mortgages, and if we have solar panels are a big thing now. And initially, with solar panels, the companies would file a UCC lien. So when you signed a contract, 20-year contract for them to install solar panels without any cost to you, and to share the electricity you're getting from the solar panels, they would put a uniform commercial code financing statement on record, both at the town clerk, perhaps at the state attorney general, Secretary of State's office, and at the registry of deeds. And this would say to the world that this party owns an interest in the personal property. Now remember, it's personal property, it's not the real estate. That's why they're not filing a mortgage on it. It's personal property, but that personal property is affixed to the real estate. Many times we had these with heating systems, where a party went and had a heating system installed by a heating system contractor, and they paid for it over a matter of a number of years. And the contractor would put a UCC financing statement on there. These are liens. They're liens on the chattels that are essential to the property, of the personal property that is essential to the operation of the property. And we are going to have to release those, obviously, in a sale, and if the property is going to be mortgaged. Now, we'll talk about subordination of these in a minute, but these are liens on the property, and they are prevalent. What a lot of the solar panel companies have done now, however, is eliminate the UCC filing. They're not making it a lien anymore. It's simply a contract with the seller. With the owner of the property. And when you see, if you're listing a property and you see there are solar panels, you've got to do some due diligence and find out how much is owed, is the contract transferable, and when the buyer comes, the buyer has to be made known that this is a contract that's affecting the property for a number of years, and they've got to get all the information based on it. Are they going to assume that contract, or do they want it paid off at closing? And we see it both ways. There is no single way that it's being done. A mortgage. Well, when you give a mortgage in Rhode Island, like if you give a mortgage in Massachusetts, you're actually giving title to the property to the lender, with your absolute right to redeem that title if you make all of your payments in accordance with the promissory note of the mortgage. So Rhode Island is a title state, a title theory state, and it kind of surprises people all the time that the lender actually does own your property, but you have the right to redeem it back. So we say that the lender has the legal title, and the lender we call the mortgagee, and secures the underlying debt, which the mortgagor, which is the party giving the mortgage, can reacquire or redeem by paying the debt which the mortgage secures. The equitable title remains with the party that owns the property, with the mortgagor. So when you give a mortgage, you retain the equitable title, the right to get it all back. You have the first right to get that back from the lender if you make all of your payments. And if that's paid off, and the lender will discharge its lien on the property and will give you back your full legal title to the property. So what that means in Rhode Island and in other title theory states is foreclosing on a property is very simple. You already own it. All you have to do is meet certain notice requirements and then hold a foreclosure sale in accordance with the state law. That's it. Now, in other states like New York, where they don't have a title theory, you actually have to go to the Superior Court. You have to file a claim. You have to potentially have a trial on the claim, and it can take a long period of time. Until 2008, when we had the downturn in the market and foreclosures became rampant. There was about a 30-day notice requirement to start a foreclosure in Rhode Island. That has now progressed, and I don't even want to pretend to tell you that I know exactly how it's been updated today. But you can't just foreclose on somebody today. It takes a certain period of time, and they have the right to cure their default. If they aren't making their payments on the promissory note, they have the right to cure that default. A certain number of days to do that. It's been extended for many times. So in Rhode Island, title theory, lender owns the title to the property, and the borrower has the right, the owner has the right to redeem that title. In some states, we call these deeds of trust. And actually, the deed is given to a trustee to hold on behalf of the lender and the owner of the property, and to be redeemed by the owner when the mortgage is paid, or given to the lender if the borrower is not making their payments. So you'll see that term sometimes, deeds of trust. Insurance. What types of insurance do we have? Well, we have property and casualty insurance. That is an annual premium. It insures against the loss or damage arising from a future event. It does not ensure that the damage won't happen. And it is risk based on the probability of loss. So when you have your homeowner's insurance, it's risk loss insurance. If you get a loss, they're going to pay it. How do they determine your premium? By the risk that's there. How old is the property? How far away from fire hydrants is it? How well is it maintained? Things of that nature. Title insurance, and again, it doesn't ensure that your property is safe. It ensures that if you do have a fire or a casualty, they'll pay the claim. Title insurance is a little different. It's a one-time premium. It's paid at the beginning and never paid again. It insures against the loss caused by a superior claim or title arising from a past event, meaning that if your title to the property is challenged, the title insurance policy can come into play. It does not ensure you have good title. Again, just like your car insurance doesn't ensure you're a good driver, this does not ensure that you have good title. What it says is that if you have a problem with your title, that they will help to fix it or pay you for it. And the risk, the determination of the value here is based on the research done in this chain of title, which we'll talk about. So title insurance, again, does not ensure you have good title. They have two policies, the owner's title insurance policy and the lender's title insurance policy. The lender's title insurance policy is of no value to the homeowner. No value to the homeowner. I've seen many people in the realtor community say there's no need to get owner's title insurance. They've got the lender's title insurance. No value to the homeowner. Why? In order for the lender's title insurance policy to kick in, three things have to happen. One, the property has to be foreclosed on. Well, at this point, then, it's obviously not going to assist the buyer, or the homeowner rather, because they've lost the property. Second, there has to be a defect in the title. And third, there has to be a diminution in the value of the property due to the defect in the title. And the lender's title insurance policy will cover that loss of value only to the lender. So if they lose money because there's a defect in the title when they're foreclosing on the property, what is the value of that loss? That's what the title is on the lender's policy. So again, no value to the homeowner. An owner's title insurance policy is good for the entire time that the homeowner owns the property, one-time premium, and it covers not only that they have that covers their title to the property, but it also covers some important things like access to the property, that they have legal access to the property. We've seen many instances in which the parties don't actually have legal access to the property. They thought they did. They thought they had an easement. They thought they had the right to drive over their neighbor's property, but they didn't. Things of that nature. Or the house, somebody claims the house no longer is in zoning compliance, but never a claim was made on them. The title insurance, many of the title insurance policies today will cover against things like that. So title insurance, I have to tell you, I know that everyone knows that the closing agent gets part of the premium. They run the risk too, because they also have to insure to a certain degree the title that they're recommending to the title insurance company and suffer a loss on that if possible. However, I've owned property in my life, many properties, and I would never purchase property without title insurance. And I also was the state manager for First American Title Insurance in Massachusetts. I paid a lot of claims, and I've seen some of the claims that come up, and they can be substantial, hundreds of thousands of dollars for simple problems, $30,000, $40,000 for simple problems relating to a property line. One thing I will always advise everyone in the realtor community: never, ever, ever talk anyone out of getting title insurance. You don't necessarily have to recommend it, although I would, but you don't have to. But don't talk them out of it, because I've had situations where realtors years ago talked people out of it, and then a problem arose and the people sued the realtor for talking them out of it. So just don't do that. How do we research title? Well, in Rhode Island, you look at every city and town and you research title. You research the ownership title of the property. They have indices that we look at. And all of these are recorded in the grantor-grantee index. We'll look at a deed and we'll see that it was granted for someone else. So that's the grantor index, and we keep going back and back and back till we go back 30 years or 40 years, however we want to go back to determine the ownership of it. We have what's called present owner searches, which are current owner only, and we do this mostly in real estate mortgage transactions. And we have full searches, which go back a number of years, that's required by the state, in which we do these for purchase transactions to make sure that the current owner has good title to the property. The chain of title is a chronological order. We literally go back deed to deed to deed to get to a certain starting point that we're comfortable with. 39 towns have availability online. So if you want to look up someone's deed, these 39 towns, and that's a URL, I'm sure many of you are familiar with it, you can go on there. And by the way, I'm going to have my email address at the end of this. If you'd like a copy of these slides, I'll send them. You can go on there and you can do research. You can look up titles. You can look up who the current owner is. I always tell realtors, when you take a listing, I highly recommend you do a little research on the owner. Again, I've been involved in many tens of thousands of transactions. I have seen instances in which Jimmy is selling the property, right? He comes to you and he gives you a listing. The problem is that Jimmy's mom owns the property, but Jimmy figures he's getting it someday. So what the hell? He has the right to sell it, but he doesn't. And we've gone all the way to title and say, wait a minute, who's Jimmy? The property's owned by Mary. And yet, well, now we're a month and a half down the line. That can be a little embarrassing. So I highly recommend. I've also had situations in which the husband comes in to list the property. Be nice if he brought his wife in too, but he didn't. And somehow he thinks he can sell the property and not let her know. You don't think these things happen? They absolutely do happen. Sometimes a little research can be helpful. A question from Paul: what happens if you refinance? Does the original title insurance remain, or must a new policy be taken out? No, the owner's title insurance policy maintains for the entire ownership of the party that owns the property. It does not have to be renewed, even in a refinance. If you sell the property, yes. Lenders' title policies have to be renewed. A new policy is issued every time a new mortgage is put on. So if you refinance your mortgage, you will pay a new premium for the lender's title insurance, but not the owner's title insurance. This is what a title report looks like. This is what our abstractors, the people who research our title, will look at. And they'll tell us, what mortgages are on the property, are there any easements on the property? So this is the cover page. This is the synopsis of the title. And this is a synopsis of, say, Milton Shaw's ownership of the title. What happened during that period of time? He gave a mortgage to the Needham Co-op. He had a petition filed for something to do with the property. There was a discharge of the mortgage, a declaration of trust. So we have these pages that we look at. We have plans that we look at. They're recorded at the registries of deeds as well. So we look at the plans and we make a determination. Where is this lot? What does lot 20 look like? What are the meets and bounds descriptions of lot 20? We have the deeds, they're recorded. We have the mortgages, they're recorded. And then the other liens and easements are recorded. And we look at them to determine what indeed they say. Common title issues, probate of estates. Again, something we could talk about for a long period of time. But if you die owning the property with no other owners, or if you're tenants in common, then your estate has to be probated in the probate court. When you die with a will, it's called you die testate. When you die without a will, we say you die intestate. And the probate court will determine who will get your property. Powers of attorney, we have to be very careful with these. Powers of attorney can be utilized, but they've got to be approved by the title underwriters in order for us to use them in real estate transactions. If it's simply for signing seller documents other than the deed, we don't worry about them. But if somebody wants to sign a deed under power of attorney, that can be difficult. And remember that powers of attorney terminate when the person dies. So if you're doing one for a person who's desperately ill, once that person dies, the power of attorney is no longer out. Mortgages, new and old, these are the real problems we run into. Prior outstanding mortgages, nobody paid them off. They have to be discharged. Judicial liens must be discharged. Mechanics lien, financing statements, liens of mortgages that are subordinate, like home equity loans. These are the types of things we need to resolve. Subordination means that a lien is behind another lien, so that the other lien is in first place. Hey, home equity lines are always subordinate to first mortgages. And if the person wants to refinance their mortgage, they would get the home equity company to issue a new subordination, saying that they'll be subordinate to the new mortgage, just like they were to the mortgage that they came after when the person took out the home equity. Home equity lines are like that. They don't want to eliminate the home equity. Testate succession. You know, when people die without a will, what happens? Does the property go to the state? I hear this all the time. No. Rhode Island has laws called intestate succession laws, where the property will go. Your will determines where it will go if you have a will. If not, there's a state statute relating specifically to who gets your estate when you die. So it doesn't automatically go to the state. Bankruptcy. Bankruptcy does not remove the lien on the property. Now, dependent on where everybody stands, but bankruptcies do not remove the lien on the property. So even if you file bankruptcy, the lender still has the right to foreclose on that property, but they have to get permission from the bankruptcy court. Ways to help clear unreleased liens. Mostly unreleased mortgages. We need to get a confirmatory discharge from the lender who was paid off. Sometimes a credit report or the application will show that it was paid off. Prior closing disclosure will show that it was paid off by another attorney in a prior transaction. Title insurance can come in and help on this, especially if it was from a prior owner. Title insurance company will make sure it gets resolved. Sometimes you have to go to court, but it really depends on what's going on with the transaction. But we see these all the time. About 25% of all the transactions we're involved in have some type of title problem, mostly undischarged old mortgages. 25%. And we work to clear these up. It's not easy, but we have to do it in order for the transaction to continue. Divorce. When a couple say they hold it as tenants by the entirety and they get divorced, it automatically goes to tenancy in common. So once the divorce occurs, and now we have to be very careful. We have to make sure that the court in the divorce proceedings is okay with the wife selling the property to the husband or the husband selling to the wife. We have to make sure that's okay. They don't want one of the parties overreaching over the other. So you have a couple that's in divorce and they are selling the property. We've got to look at the divorce records. We've got to find out to make sure that the court is okay with this. Also, if you've got you're selling a property from that was in a decedent's estate, we've got to look at that. We've got to talk to the probate attorney. We've got work to do in those instances. Well, that's pretty much kind of in a nutshell. And as I said, there's a lot we can talk about in a lot of these various areas, but it's kind of an overview of all of these issues. And I'll give you these slides. Shoot me an email at mcrone@equitynational.com. Happy to shoot it to you. Also, if you run into any questions, give me a call. Or rather, email me is probably the best way to get me, because I don't necessarily always answer the phone, but I always answer my email, depending on if I'm in a meeting or whatever. But feel free to email me. Certainly happy to help your buyers and sellers, anybody that you would like us to work with. We know what we're doing. We're pretty good at it. We've been in business 30 years, so we're always available to help. Does anybody have any questions they'd like to ask right now? You can unmute yourself or you can shoot a chat in. We've got a few minutes left. Happy to answer any questions.
Michael, I'd like to get an update on the question that Paul asked specifically, where the original title insurance policy, whether or not you have to get a new one when you refinance, which on a lending standpoint, we normally don't require that at all. However, my understanding is that should that person have purchased a property or inherited it, they might not have it. So if they're refinancing, their pre-existing one from either the family member or maybe at that time they were unmarried, now a spouse is going on the transaction, it doesn't carry over to the added person. Is that correct?
Not necessarily. So if you add a spouse, it's as long as the other spouse is still on there, it continues.
All right.
So you don't have to change it. Yes, if you get it from an estate, if the prior owner had the policy and now it's transferred ownership to you, you don't necessarily have the benefit of that title insurance policy if you take it to an estate.
On the same avenue, should the spouse, so there's, let's say for instance, in this scenario, there was an original spouse purchased the property, got married afterwards, after the property was purchased, and that owner's policy is in their name specifically, that new spouse is now added onto a loan they refinance 10 years down the road. The first spouse, the initial original one, passes away. Does that coverage still carry over to that new spouse who was added onto the property title 10 years afterwards?
Generally speaking, it does. But in that instance, I would want to look at the policy. I would have the people call me. I'd look at the policy just to make sure there was no restriction in that policy as to that.
Okay. All right. My second portion was my second question in terms of, well, actually was more of a statement directly to the realtors in the group. As stated, it is highly important when you're going through, especially on a lending standpoint, not just necessarily a closing standpoint or a title standpoint, but on a lending standpoint, to review the property with the town. That tenancy in common that has rights of survivorship, that purchase and sales agreement may require those other people to be legally responsible to sell that property for that individual. So for instance, the mother and father was on there and there was a tenancy in common, and that the rights of I believe that's the way it was, right, Mike? The interest goes to their heirs, correct?
Tenancy.
Yep. So at that point, so let's say mother and father on the property, father passed away, their two heirs would get his interest of the property. So therefore, on a purchase and sales agreement, all parties of interest would have to be signing away the interest, correct?
Exactly. Whoever has an ownership interest in the property has to be in the sale agreement.
Exactly. So it's why it's very important to go and do this work putting this property on the market, as the selling realtor may have to list that and have those other bodies involved in there to sign that purchase and sales agreement down the road. Because it's definitely going to come up on the lending standpoint. As we go to purchases, we'll pull title and see who's currently listed. And if there is a tenancy in common listed and there is one of them is not on the initial purchase sales agreement, it's going to come up. It's going to become an issue, which depending on where they're located could be sort of a hassle, could be a time consuming process in order to get that, son or daughter or a surviving heir who might not be in the town to come and sign the purchase sales agreement and move things forward. They'll also have to be at the closing to that issue necessarily, unless they're doing a mail away to that degree.
Right. And any even cash purchase, we always do the title search. When we do the title search, we're going to compare the purchase and sale agreement to who we find to be the actual owners of title to the property. And if one of those people isn't on the purchase and sale agreement, then obviously those other parties can't sign their interest away.
Sure.
So we want to make sure, like I said, you want to make sure when you take the listing that everybody that owns the property also is on your listing. Because let's say that, you have two people on the listing, you've got only one person both people are, one person on the listing, but two people own it. That second person isn't obligated to your listing. So you want to make sure that you do just a little due diligence from time to time on these things.
Exactly. I think it's very important. It'll doing it now up front, even though some of the towns are still slightly closed to some degree, but as Mike shared, there's the websites for everything that you can review directly on them. Most towns are electronic from this standpoint, but doing that footwork immediately at the beginning as a listing agent is going to save you time down the road in which chasing these other issues up if you can be ahead of it. So it's very, very intuitive to do that right away.
Correct. And we have a question from Janice. What is a trustee's deed? A trustee deed is when the property is held in trust. The trustee is actually the owner of the property. The trust isn't a legal entity. A limited liability company is a legal entity in the eyes of the law. A corporation is a legal entity. A limited partnership is a legal entity, but a trust is not a legal entity. And so the trustee owns the property on behalf of the beneficiaries of the trust. So a trustee's deed is a deed from the trustee, which is the way all trust deeds would be. The trustee granting the property to the new owners. Any other questions?
Michael, you're. Oh, go ahead.
Michael,
Dana.
Dana Phillips here from Rhode Island Real Estate. I've got a question regarding condominium docs, and they reduce your usage, and you have to abide by them. But when you own them for many years and they change the rules, they in essence, they can limit your usage of your unit. More recently with more of these rental VRBO type rental sites, people might rent out their condominiums, and the condo associations are putting more and more restrictions on it. So how much are they allowed to change the condo docs, or is it just, can they do whatever they want so long as they get a majority of vote at a legal meeting?
You have to look at the condominium documents themselves and see if there's any restriction first off. But generally speaking, the condominium master deed and the trust will generally allow the condominium association to make changes to the documents. There are certain limitations as to what they can do. In some instances, can't change ownership or things like that.
Right.
But primarily, so long as there is a percentage, sometimes it's a majority, sometimes a 2/3 majority, they can make changes to the documents, and they can limit your ability to lease. They can limit your ability to have pets. They can do those things after you've purchased the condominium. Yes.
Okay, thank you.
Anyone else?
Michael, you'd state the elder law type aspect of the trust that was just talked about. Does your firm, or are you a representative to estate planning, sort of probate, or trust planning? That degree, do you guys handle that?
We are not. We exclusively handle residential and commercial real estate transactions, but we can certainly always try to help somebody with a referral.
And the trust is very important. I find as you get the more senior citizen or Social Security age dependent groups, as you'll notice that there's several trusts. We notice on the lending side that several trusts go into play, which protect them from having to eventually, over a certain number of years, and I think it's 5 or more, of being in a trust, in which case they don't look at it as an asset and therefore don't need to deplete it in order to go into that assisted care or living facility or something along those lines. But the importance of the trust is that on a lending standpoint, if you plan on doing anything forward, is keeping it in a revocable as compared to irrevocable trust, because there's 2 different variations between the 2.
Right. Most lenders will allow, because Fannie Mae and Freddie Mac will allow owners of the property that hold it in a revocable trust to keep it in that trust. They will both sign as trustees, and they'll also sign personally. So yeah, an irrevocable trust that generally doesn't fly with Fannie and Freddie. The other thing, we just got a question. All owners, as you are discussing, would be listed on the tax assessor's database, owner of record, correct? No, not necessarily. I was the assessor for my town in Massachusetts for 25 years. Assessing records are not as accurate as the records of the Registry of Deeds, because that information comes to the assessors after the recording of the deeds and things of that nature. So I would not count on the assessor's records or the tax collector's records to determine the true ownership of property at any particular time. The only way to truly know that is researching the records of the Registry of Deeds. Anything else? Well, we've gone over a little bit, but thank you all of it. Linda, I'll put it back to you and to Anthony, but I appreciate all of you being here today. And as I said, you have my email address. If I can help in any way, please don't hesitate to contact me.
Thank you, Michael. That was fantastic. As always, great presentation, a lot of information, even for myself who deals with it for the last 20 years on a regular basis. I learn something new every single time. So I'm very appreciative of that. Everybody else, as you said, please feel free to email him directly, ask for the information. It can come in very handy for you moving forward as you start to list hot properties and actually start checking these registries to see this information. He's a great resource if you need it, if you have any questions to follow up with too as well. For everybody else, as for the education committee, thank you very much for attending. This is we do this every single month. We try to do a education panel or of some sort in order to educate our realtor groups in the Kent Washington Association. We're always looking for additional members and ideas. So if you do have something that might be very important to you, or you're looking for additional information in that avenue, please feel free to reach out to us and let us know, and we'll investigate it, try to get it on the board in the docket.
Thanks
Great.
a lot.
Thanks, Michael. Great presentation. Thanks, Anthony.
Thank
Bye,
you, everybody.
everyone.
Bye.
Thank you.
Enjoy your day.
You too. Bye-bye.
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 Bye.